Hello, everyone, and welcome to 9fin's latest webinar, Petrofac in the Next Chapter in UK Restructurings. I'm Danish Mehboob, Senior Distressed Debt Reporter here at 9fin. Thank you so much for joining us. Today, we're unpacking a landmark Court of Appeal decision, one that not only shaped the fate of Petrofac, but also significantly raises the bar for fairness and evidence in future UK restructurings as well. With me are three fantastic panelists who bring a wealth of legal, financial, and analytical perspectives on this ruling. And I'd love to give them the chance to introduce themselves over here. So please allow me to pass the floor over to Dorian first, who is our guest speaker. Dorian, please go ahead.
Thank you, Danish. Good morning, everyone. My name is Dorian Lowell, and I'm the Chair of Financial Restructuring at Gleacher Shacklock. I've been doing restructurings for many years, both in the United Kingdom, across Europe, and also I have a lot of experience of Chapter 11 panel reorganizations. I'm very happy to join you.
And next, please go ahead, Denny.
Oh, hello, everybody. My name is Denitsa. I'm a credit analyst at 9fin, and my primary focus is stressed and distressed companies who unfortunately sometimes have to go through restructurings. 9fin has been following Petrofac for several years, so we're quite fascinated by the recent developments.
And of course, last but not least, Luke.
Morning, everyone. So I'm Luke Viner. I'm a senior legal consultant at 9fin, and I was formerly in private practice and working in restructuring as well.
Perfect. And before we dive into the subject matter over here, I'd also like to flag that we have a Q&A session following this webinar today. So if you have any questions for any of our speakers, please feel free to submit them via the webinar console. And secondly, if you'd be interested in learning more about 9fin, then please do complete our survey that will be appearing at the end of today's session. And with those 2 points out of the way, let's get started. So I'd love to turn over first to Denny, who could you help us paint a picture and remind us about how Petrofac got to this point and ended up making history in court, please?
Yeah, thank you, Danish. I'll try to be as quick as possible, but the problem is that Petrofac, its troubles, they have been a long time in the making. So there are quite a lot of key events that have happened over the last 5 years. But importantly, the company has a very simple capital structure. It has 4 senior secured financial instruments, a revolver, 2 small loans, and a 600 million bond. The bond was issued in November 2021, and interestingly, soon after it started trading down and it has never recovered. And there are several reasons for that. The first signs of trouble started in 2021, at least recent trouble started in 2021 when the company was mired in a fraud scandal. So it was investigated by the Serious Fraud Office. It received a rather large fine, and this fine related to historical offences even prior to the pandemic, but that still shook investor confidence and importantly led to several lawsuits that will be the implications of which are also included in the current restructuring. In 2022, the company showed a serious signs of financial distress. It issued a big profit warning, and the things it reported were the usual things you expect to hear at the time about end market weakness, supply chain disruption. It talked about escalating project costs and the difficulty and delays in winning new contracts simply because it blamed it on the pandemic, and a lot of its customers were winding down business due to the huge uncertainty around the pandemic. And as a result of that financial underperformance, its liquidity started to erode. And between 2022 and 2024, these challenges persisted and even exacerbated. So the company had no chance but to do an immense extent of its debt facilities in order to buy some breathing room for it to operate. But more importantly, in addition to that, it also had to amend its covenants on several occasions. And that was troubling because it showed that the anticipated recovery that was baked into its business plan simply never materialized for whatever reasons. And this financial pressure actually was then slowly reflected in the loss of its credit rating. So the company was downgraded from a BB- in 2021 at the time of the bond issuance to a B- in 2023, and then to a triple C minus in 2024. Now, the important thing about the weaker profile is not only that if the company earns less money, its capital structure become a little bit less sustainable. But in 2023, Petrofac specifically struggled to obtain performance guarantees from credit insurers. And that is particularly important because it is a contractual obligation for companies like Petrofac to have those performance guarantees in place in order to start work on new contracts and new projects. So they had to find a temporary workaround, and that involved posting cash collateral with clients. But the company quickly ran out of cash. In May of last year, the company could no longer afford to service its debt. And in the summer of 2026, when it was asked by a key client to post additional collateral, it struggled to do. This is when things become exceptionally unsustainable, and the company and its advisors realize that they have no choice but to restructure the company via the courts. So in December 2024, they launched a UK restructuring plan. The plan was sanctioned. It was heard of by Justice Marcus Smith, and it was sanctioned quickly in May 2025. But immediately came under fire by two dissenting creditors. And the two names of the creditors are Samsung and Saipem, and I think they're going to appear time and time again in our discussions. And the interesting thing about them is that they're not only creditors to the company, but they were together with Petrofac joint venture partners in a clean fuel project where the client was Thai Oil. The issue that those dissenting creditors had is that through the restructuring plan, Petrofac will be managed to get rid of their liabilities, but that means that they will be stuck. Samsung and Saipem will be stuck with their liabilities, and in order to those to be extinguished, they wanted to be remunerated fairly for those. Now, the key objections they had is that under the plan, they were worse off versus the relative alternative, and that the benefit that was generated by the plans were not fairly shared. And this is something that I'm sure we have time to get into more detail later. But the important thing is that actually this appeal succeeded, quite surprisingly. It was heard last month by three appellant judges, Judge Snowden, Zaccaroli, and Floyd. And that's quite important because Judge Snowden is a key authority in UK restructurings, and he also has been a key decision maker in previous cases that might prop up on those calls. So it's important to keep that in mind. So yeah, I think the key takeaway is that this has been a very slow descent into trouble. The company did struggle for several years to turn around its performance, and now it has failed to appeal, and basically it struggled to put together a fair restructuring plan. And this is why we're here.
Wonderful. That's great background. With that, I'd love to dive further into the judgment now about what happened and why it matters. This is a landmark case, and with that, I want to turn to Luke first. Luke, could you add to the scene setting that Danny just gave us and walk us through the Court of Appeal's decision? What are some of the key takeaways that you saw?
Sure. So as Danny mentioned, Samsung and Saipem, they brought their appeal on two grounds. So the first was around the application of the no worse off test. So this is part of a statutory test where it needs to be satisfied in order for the court to be able to sanction a plan where there's a dissenting class of creditors. And the company has to show that the dissenting creditors would be no worse off under the plan than they would be under the relevant alternative. Now, Saipem and Samsung, their argument was that the initial High Court decision was incorrect. The test wasn't satisfied. And part of their argument was that under the relevant alternative, which was an insolvent liquidation of Petrofac, they would be freed of a competitor in the market. So effectively, liquidating Petrofac, it would no longer exist. Their market share would increase. And I think they gave a figure of around $340 million that they could have gained by Petrofac not being in the market. And they were saying that, Saipem and Samsung were saying that this should have been factored into the scope of that test. It's certainly a novel argument, but I don't think many people would have been surprised by the fact that they didn't get up on this ground. Although it's an issue that it didn't really dominate the pages of the Court of Appeal judgment, the Court of Appeal did actually clarify the scope of that test, and they gave some guidance on how it should be applied going forward. So while they agreed with Justice Marcus Smith that the loss of a competitive advantage should not be considered under that no worse off test. They reached that finding for different reasons. So in the initial High Court sanction hearing, this concept of remoteness was used by the judge, whereas the Court of Appeal clarified that approach. And they've said that what the court needs to do is actually assess the actual value of the rights that are affected by the plan. As an example, they flagged that nowhere in the joint venture agreement between Petrofac, and Samsung did the appellants have a right to stop Petrofac from trading. And so what the court was saying was they didn't have that right to begin with. So it wasn't a right that they were being asked to give up under the proposed plans, and it wasn't something that was being compromised. Now, the second ground, and this is probably something that we're going to delve into in a bit more detail as this session goes on, but their second ground of appeal was that the judge should not have exercised his discretion to sanction the plans because what's come to be called the restructuring benefit. So the benefit or the value that's preserved or created by the plans, that wasn't allocated fairly amongst the creditors. And there's quite a few issues to unpack in relation to that second ground, largely because this element of fairness has been brought in, and there's not really any prescriptive guidance as to what is a fair allocation. There's no magic formula for that. So the court has to conduct a deeper inquiry into what that means. And I think, actually, I'll probably leave it there in terms of that point, just because there's probably a lot to discuss and that we're going to discuss in this session. As far as key takeaways are concerned, the central issue here was really the new money. New money is going to be crucial in these kinds of scenarios. And I think this decision is going to impact how plan companies will justify the terms of that new money, how they're going to approach negotiations with their creditors, and also the extent and the scope of the evidence that they're going to need to file if they want to go to court and ask the court to exercise that discretion to cram down a class of dissenting creditors.
Wonderful. Thank you so much, Luke. And Dorian, I'd love to bring you in over here. Did the Court of Appeals judgment surprise you in this case? And what did you think about the two grounds for appeal?
It didn't really surprise me. I think we were going to end up here. I think if you take a step back, when you look at SIGA 2020 coming in and Part 26A being drafted, everyone wanted a cram down provision. And my sense is we did borrow from Chapter 11, but we decided not to incorporate the absolute priority rule, whereas other jurisdictions in Europe did. And we decided, no, it was inflexible and we wanted the flexibility. So we don't have absolute priority. We have this discretion based on the explanatory notes to the legislation, which talks about the court not having to sanction if it's not just and equitable, which is the sort of, I would say, a bit of a distortion of the fair and equitable language in Chapter 11. And so you now got a discretionary element to the statute, which has led us into this problematic area of what is fairness and how do we now evaluate fairness on this horizontal comparator between assenting and dissenting classes, and how the benefits that have been preserved or generated by the restructuring are allocated. And whenever you're going to have a discretionary element in a statute, you're basically saying the courts are going to have to figure it out. And it's become difficult to figure out. And then the other, I think, element that complicates matters is it's just become the norm in UK restructurings that you have restructuring plans based on new money. And the process is really controlled by the senior creditors and an ad hoc group. And they basically negotiate with the debtor on how new money is coming in. And I have no doubt that when you look at the practice in the market, special situation funds do buy into cap structures and buy the relevant, typically the senior part of the cap structure. They buy claims at a discount because they want to get on the committee and they want to shape the new money. And then they're in a position where, and we saw it in Adler, and we've seen it in continental jurisdictions, such as in France, in Orpea, where you get the controlling ad hoc group basically, I don't want to say dictate, but are basically shaping the new money plan and how new money goes in and what it gets and what the creditors get riding on the coattails of the new money, brings precisely all the problems that we now see in Petrofac. And so you get stakeholders wearing two hats. They're wearing a new money hat, could be new debt, could be new equity, and they're wearing a creditor hat. And they're getting a lot of value out of wearing those two hats. Some of it's on account of the new money. Some of it may be on account of the way they are participating in the restructuring in their capacity as a creditor. They get onto a committee, they get work fees, they get elevations, they get up-tiering, but it's all part and parcel of we're in control, we're going to put the new money in, and these additional benefits come along. And then you get to the point where the junior creditor says, hang on, this is out of equilibrium, this is not fair. And I don't think that the way I've contributed, and I think this is an important point, my contributions as a junior creditor, or even as a pari passu creditor that can't participate in new money, are not being afforded fair treatment. And we have this really messy situation now in 26A cram down cases as to what do we mean by a fair allocation of the restructuring benefits that are being preserved or generated by the plan, and who's contributed, and how do you value contributions? And I would say in the old days for me at least, were, if you remember the old days of loan to own, you would buy into the cap structure, you buy the fulcrum security, you buy it at a discount, and you say, I think that in the restructuring, this is the fulcrum security, I'm going to be impaired on my claim, but I don't mind because I bought it at a discount and I'm going to be equitized. So I'm going to get all the equity. And the only caveat to that is if new money then came in, the new money would dilute the equitized deficiency claim of the impaired creditor. And as a result of that, the waterfall structure and the cap structure on a pro forma basis would change, and the equity splits would get re-divvied up between new money and impaired creditor who had contributed through her write down. And now you see in Petrofac, you've got Samsung and Saipem saying, look, we have huge claims against Petrofac on account of this clean fuel project. And so we think we've contributed an enormous amount and we're not getting our fair allocation. And I think they would say, because I went back and looked at the skeleton, they're basically saying we think the equity allocation to new money is inappropriate. And so then you've got to, and I'm guessing it's Snowden who wrote the judgment, let's assume it is, the Court of Appeal judgment is making progress now on how in this world of discretion, they're trying to build a template so that we can go down and look at how we deal with these issues. And you're looking at it on a day one value basis, which I think is correct because that's how the secondary market for debt operates. Everyone looks at the value of their claims on a day one basis. You look at enterprise value on a day one basis, and your enterprise value based on the pro forma fully funded business plan as valued for plan purposes. That's the going concern value. And you look at that, and you should be able to go down that capital structure waterfall and say, out of that enterprise value, you've got to allocate X to new money, which may be debt, and you've got to allocate Y, which may be new money equity. They've got to get their returns on their investment, and they've got to get the returns of their investment. And the rest is distributable value. And that distributable value should be allocated by class in priority on a pari passu basis. And I think reading between the lines, what Samsung and Saipem are saying is, look, the new money here, the new equity, 219 million by 68% of the equity. So grossed up, that's worth about 322 million. And then Tenyo's coming in with a sort of midpoint valuation of 1.6 billion day one value. So if I've got 68% of the equity just for putting in 200 and whatever that amount was, that 222 million or whatever, or 219, and it was let's say, floated on the London Stock Exchange the day after, and it hit that 1.6 billion valuation, they would make outsized returns. Now, that doesn't mean that they're not justified in making them. I think that's a different issue. But you just look at that and someone scratching their head and saying, that doesn't seem to be a fair allocation to equity, to new money equity. That seems to be at a premium. And that's why I'm getting, let's say, lower returns. And look, I haven't read the explanatory statement. I've spoken to people much closer to the deal. There's a lot of complication around this company. It's a difficult company to finance. I talked about the guarantee lines, the performance bonds that are needed. All that's yet to come. I don't doubt that the value going forward is maybe difficult to value. It may be risky, but if a financial advisor is coming out saying there's a day one value of this, and a small amount of equity is going to get the lion's share of it, I think that struck the Court of Appeal as suspect. And that's why they basically said, go back and substantiate how bad it can be.
Fantastic. Let me bring Denny in really quickly about, Denny, you mentioned that there's something you wanted to touch on over here, and that's the key things that the court looked at on the mechanics of the deal. Can you briefly give us your perspective on that?
Yeah, of course. More broadly, Dorian did quite rightly point out that because the key complaint resolved around the distribution of the benefits between the plan creditors. Therefore, this is what the appellant judges looked at. They looked at the compensation for the compromised creditors, the compensation for the new money providers, the cost that could be obtained for the new financing in the market, and what benefit was generated by the plan. And also to what extent these creditors are entitled to share into the distribution of that benefit. And there is a lot of moving parts and a lot of factors that they considered, a lot of numbers that they had to quote. But there is, I think, one slightly minor element around the mechanics of the work fees that actually proved to be very important to the concept of fairness. And it's quite easy, if you just looked into it, to understand why the appellant judges had an issue with it. So the judges paid particular attention to the work fees that were payable to the ad hoc group and how they were calculated, because they were structured in an unusual way. So I'm just going to quickly give you the numbers so that we understand how the judges reached their conclusion about things being not quite fair there. Basically, the appellant judges pointed out to the fact that the work fees that were not calculated based in reference to the amount of work that the senior creditors spent on negotiating the deal, they're not in reference to the actual work that was done for the restructuring, but they're simply a fixed percentage of the compromise claim. So the ad hoc group was said to have something in the region of 322 million of holdings. And the company roughly calculated that this will translate to 7 million of fees. Now, there was a catch here, because those work fees paid to the ad hoc group, they were conditional on the outcome of the restructuring. So if the restructuring was successful, then they'll get paid in equity, and that equity is linked to the value of the post-reorg company. But if the restructuring failed, then the fees will get paid in cash. And in this case, they will be linked to the compromised debt. Now, the difference here, as you can see, the value of the compromised debt stays the same. It's fixed at a point in time. The value of the equity will fluctuate over time because the equity is a trading instrument. And it's certainly the company's expectation or estimates of the value also seem to be quite variable. Early in the process, there seemed that there was some confusion around that, because the first attempt to get a rough estimate of the work fees suggested that the company used a valuation of around 350 million. And later on in the process, when the company's expert put forward their report and valuation, then we came up with a much bigger number, or a range, for the post-reorg value of the company between 1.5 and 1.8 billion. Now, as you can imagine, there is a big difference between 2.5% on 350 million and 2.5% on 1.5 billion. So the appellant judges quite rightly pointed out that you start off with 7 million fees, which if the restructuring is successful could potentially jump up to 30 million of fees. And that in percentage terms, the cost of the work that has been agreed or pre-agreed back in December 2024, all of a sudden has the potential to jump up to 400%. And this is in contrast with the fact that the quantum of that work that is put into the whole negotiation hasn't changed. Because the post-reorg equity becomes part of that benefit, overall restructuring benefit that needs to be shared equally by all shareholders, then there was a bit of an examination whether it has been, and Sapim and Samsung quite rightly complained that they didn't think that the way that the equity around the working fee was distributed fairly. I think when the appellant judges looked into the mechanics, they concluded three things. That first, that there is no adequate explanation given as to why the equity was structured in such a funny way. Also, that the company didn't provide any evidence about market testing and benchmarking. For example, if you are to go to the market and to seek new money from a completely new set of investors, would they agree to give you the money at the same price for the same work fees? And Judge Smith at the time didn't ask for such an evidence, and he didn't consider those factors. So therefore, I think the key takeaway for me, but also I think this is a key takeaway that might potentially be relevant for the company advisors, is that if you're a company and you're working with your senior creditors and ad hoc group and you're thinking how we can remunerate for that, for your work, simply saying to the judge, hey, we're the only creditors that we're prepared to give you money. Nobody else wants to deal with this company because the company is in a really big financial mess. It's really risky. And because this is the only price that's on the table, therefore, by default, it must be a competitive price. That is not enough to prove the point on fairness. And also, there is another argument they were trying to put forward that, but we offered other creditors to participate in the new money, but they refused for whatever reason.
Sorry to cut in, Danny. I'm just conscious of time because we are running at 11:30 right now.
Yeah. So basically, the judges said that simply saying that offering participation to all and offering equity to all is not enough. It's the proportionality that matters.
Absolutely. And now I want to turn on to one of the most consequential parts of the judgment, how courts now come to expect companies to justify fairness, especially when it comes to new money and evidence. So on this particular point, I wanted to first turn to Luke and ask, based on what the court said about fairness and market testing, does this affect the predictability for practitioners moving forward? Could you give us a perspective on that?
Sure. I think we'd all be thrilled if we had a bit more predictability in these situations. In relation to market testing, and this is also from some discussions that I've had with people in the last week or so, I think there's going to be mixed views on that. From perhaps a surface level view, you can look at what the court has said and what they're asking for from Petrofac and say, yes, the company should have put in evidence on whether they went to market and to see what deal was out there for new money. As Jenny mentioned, the evidence that they put in was in relation to the negotiations that they had with just the new money provider. And they said that were hard-fought negotiations. They weren't able to get a better deal from Nuttree, but that wasn't enough to satisfy the Court of Appeal. From a more practical point of view, I think it's going to be interesting to see what that evidence of market testing will look like. Will it be sufficient for a plan company to put in a witness statement and say, yes, we've gone to market and this is the best deal out there? Unlikely. I'm sure there'd be plenty of people that would be delighted if it was that easy. But the Court of Appeal did actually say in Petrofac, the most obvious way to demonstrate this would have been by expert evidence. And so that expert evidence and the assumptions that are applied to the report that comes out are going to be heavily scrutinized. Things like how the market is defined. It's also going to be highly fact sensitive. But I'm not sure it necessarily creates a lot of uncertainty, at least on that point. And then in terms of fairness, I do think that's going to create more uncertainty for a plan company if they're going to go to court and ask for a cross-class cram down. It's not a concept that can be easily quantified. So there's no, I think I said before, there's no formula as to what is a fair allocation. And then also related to that and predictability, dissenting creditors, as a result of this, they've been given a better seat at the table. Before Petrofac and before Thames Water, companies may have been a bit more confident in going to court and asking for a creditor class to be crammed down, but now it's clear that those creditors that are out of the money, they need to be considered, they need to be offered a piece of the pie. And there's a very clear quote from the Petrofac Court of Appeal judgment on the purpose of a cross-class cram down, and that it's not designed for assenting creditors, excuse me, it's not designed for assenting creditors to give themselves an equitable share of the benefit of the restructuring. So for predictability, the emergence of this fairness principle, it does mean that companies are going to come up against more resistance when asking the court to cram down a class.
Thank you for that, Luke. I'll also want to build on that with Dorian, given that, let's take it a step further. The judgment focused heavily on the cost of new money. And what kind of evidence will the courts now expect moving forward? I believe Luke built a little bit on this, but Dorian would love your perspective as well.
Look, there's plenty of data out there. And if you look at new money coming in as debt, again, you've got to take the pro forma business plan. You've got to look at all the financial metrics. You've got to come up with a shadow rating, and you'll get a spread over the risk-free rate. And an expert will say, look, I think the spread should be X given the metrics. And I guess the other side, the lenders will argue high and the company should be arguing low. But that, I think, is less controversial. It's going to be more easy to satisfy than how you split equity. What is an appropriate return on equity for new equity coming in for a company like Petrofac, which I understand went out to market for a very long time and people were very reluctant to invest in it. And one of the problems is that they've got to get guarantee lines in order to get the cash flows on which this pro forma valuation is built. And you can't operate Petrofac without performance bonds. It's unclear as to, when you look at Petrofac, how did the 10-year valuation factor in the risk of performance bonds, and how does that impact what an equity investor wants based on how he perceives the equity risk in the company going forward? But again, there's plenty of data on what, for example, private equity sponsors expect in terms of money multiples, or I think it'll be a bit of a battle of the experts. But I also think, as a result of Petrofac, it's going to be scrutinized, and the returns on equity might get squeezed. Just returning to the work fees point, I'm very cynical about work fees. For me, it's just an ad hoc group that form a committee in order to goose their returns by negotiating the highest work fee they can. You don't get it in Chapter 11. You can make an application in Chapter 11 as a creditor for substantial contribution. They're really difficult to get. But you have an official committee in Chapter 11. They don't get paid a work fee. So it's a UK European invention in order to allocate some value your way because you've been shut in a conference room for 18 months. If you didn't want to be shut in a conference room for 18 months, don't buy the debt. I find it a bit, I'm a cynic when it comes to these things. But in terms of evidence going forward, I think people are now going to be really circumspect. If we're going to cram down, and this is what we want on this, these are the equity returns we want, and this is the cost of new money debt, they're going to have to prepare some fairly probative, cogent arguments for justifying those rates.
And just for the sake of time, I'd love to get to our last section, which is on practical lessons for the future plans. So thank you so much for that perspective, Dorian. So can we now take a look at the impact on live cases in court and for the wider restructuring regime? Again, I'd like to start with Luke over here. How do you think Petrofac's judgment ties in with something that's developing recently, which is the High Court's new Part 26A practice statement? And if you could give us a little bit of background on that and where things are going, that would be fantastic.
Sure. So I think the judgment, it definitely echoes a similar sentiment that's in the draft practice statement. For those who may not have seen it, so the court has circulated an amended statement, which is its guidance on procedural points in relation to Part 26A restructuring plans. And the judiciary has invited comments from the industry on the draft. The final version is due out, I think, in the next few weeks or so, definitely over the summer. But the underlying motivation for that is the court wants to encourage parties to engage with each other earlier. And for case management purposes, for court resourcing, they also want the parties to come to court with as few issues as possible. Now, in an ideal world, we'd all like that. There would be enough time to negotiate and have those discussions to get creditors on board, but it's just not commonly possible in these restructuring scenarios. Now, there's also been some comments from judges in recent cases which reflect that they're recurring, is that the court is being asked to look at very complex issues in a very short amount of time, and the urgency that's put on them to have to deal with those issues. As an example, in Petrofac, those pressures that were put on the court and on the advocates, they were highlighted in the April judgment. And so it's a big motivator for the amended practice statement to be put in and finalized, because it's already coming through in recent decisions where these points are being highlighted and flagged by the judges to say they're not happy with how things are being presented. Now that then puts a lot more pressure on the practitioners and on the plan companies, because there's already an incredible amount of work that goes into these restructuring plans. And then you add on top of what's already being done, the increased scope of evidence in relation to fairness and allocation. And it then starts looking like this process, the restructuring plan, is very complicated, very time intensive, and it almost makes it a slightly less attractive option in terms of restructuring regimes in Europe and compared to Chapter 11.
Fantastic. And Dorian, how do you think Petrofac affects a company's leverage now and changes how it should negotiate with potential dissenters moving forward? Is it riskier to push aggressive plan terms at this stage?
So I think if you're just an ordinary C corporation and you've got your creditors and you've got potentially a new money investor, your old shareholders are not involved, they've walked away, and you've got some junior creditors, I think the plan company with its financial advisor and its legal counsel will basically say, look, you've got to take into account Petrofac now. We can't have a plan that seems to be skewed in the favor of, let's say, sort of new money, which may or may not include existing creditors. Otherwise, it's just become a lot more convoluted in terms of sort of litigation and costs. And so everyone's just going to, I think, have to become a little more realistic about how they're prepared to divvy up the pie between the different stakeholders. If you are a private equity sponsor company and you're trying to put in the new money because you want to retain your portfolio company and you want to work with the senior creditors and squeeze out the junior debt to sort of rebalance the debt equity ratio, then I think the leverage moves more to the junior creditors saying, and I think there's a parallel with liability management exercises. It's like, if the company and the senior creditors are going to combine forces to do new money and enhance the returns of the senior creditors at our expense, we're confident that we can bring a Petrofac kind of appeal and slow you down. So I think it resets a little bit the playing field, because I do think ad hoc committees have the negotiating leverage in their favor in the past. They've basically been able to come to the company and say, we're the ad hoc committee, we speak for the senior creditors, you can't do a deal without us, we have to consent if you want debt reduction, and we're also putting in the new money, and we need these kind of economics. And they've managed to bulldoze it through. That, I think, changes a bit after Petrofac.
Wonderful. And Denny, very quickly, I would love to get your take about something over here. With those legal and market shifts in mind, let's talk practicalities and what this means for Petrofac. What will happen next with its plan? Could you give us a perspective?
Really, the short answer to that is we don't know. There are quite a few questions that we need to get the answers first before we get a clear picture how things will progress. However, we know that the judgment is set aside. We know that the company now has 21 days to escalate it to the Supreme Court. But let's just say for simplicity, they don't. That means that they had to sort out this mess between themselves. And because the judgment says it is the company that put forward an unfair plan, at least to my non-legal mind, this suggests that the onus is on the company to figure out a more fair distribution of benefits between the different creditors. And what We are not given any guidance on how this will happen. So one question I was thinking about is whether potentially they can do an out-of-court deal with Samsung and Sapim and then just very quickly rerun this deal through the courts. Is that possible? There is, if you remember, in April, the two dissenting creditors, they put an offer on the table, trying to find a consensual solution. They asked for 100 million in order to extinguish their claims. However, there are a few questions that need to be answered. First, is this offer still open? We don't know about that. Secondly, the senior creditors have already rejected this offer. Does it mean that in light of this judgment, they will be more enticed or incentivized to accept it? And thirdly, is that 100 million that Samsung and Sapim are asking for, is it actually enough to satisfy the fairness test? Because it's my understanding it's the judge who decides what's fair, not the parties necessarily themselves. And how much more can those compromised creditor get? I think that we don't know the answer to those questions. And my biggest concern is if the company is to be believed, during the actual sanctioning hearing, they're making a big song and dance about how they're going to run out of liquidity, how they're going to be pushed into insolvency unless the court gives them an answer very quickly. If they spend 21 days or a month and several weeks in the Supreme Court, or if they spend several weeks or months renegotiating with creditors, isn't there a risk for them to actually run out of liquidity? And does that mean that they need bridging finance very quickly? And then don't we then come up to exactly the same problems? What is a fair cost of that bridging finance? So actually, we're very much in the dark here. We have so many questions that we want the answers for, and nobody's telling us.
Of course, we can appreciate that. That brings us to the end of our main discussion, but I would love to take a few minutes. I know we're at 11:45, but let's take a few minutes to open it up to audience's questions. And I'd love to give the chance to the panel where we would like to take the first bite of the apple when it comes to answering audience's questions. Please feel free. Just take a look and see what we've gotten over here. So the first question that we have is, does Petrofac make it harder for companies to rely on insider or sponsor support in distress situations? Are we heading for a return of third-party led restructurings? Would anyone like to take that?
Not necessarily. Again, I think it's all down to the economics. What economics are you extracting? What are the recoveries for new money, and what are the returns on new money, and what are the recoveries for creditors is going, and it should be more objective, and it should be based on ordinary restructuring corporate finance principles. I don't think it necessarily gives, I don't see why it would change the dynamic between a sponsored company and non-sponsored company. I think everyone's going to be cognizant. I think there's going to be a new verb in the restructuring community. If you don't play fair, we're going to Petrofac you.
Appreciate that. Would anyone else like to jump in over here?
Just to say, no, I agree. I think that there may be a slight change in how the dissenting creditors approach the negotiations. They're going to be saying, look, give us a bit more than you're offering, or give us a higher recovery. Otherwise, we're going to challenge this. And then, yeah, as Dorian has termed, we're going to Petrofac you.
And then another question that we've gotten through the audience is, should debt investors now be baking in Petrofac premium when pricing UK restructuring risk?
Not if they do it correctly. What we're seeing is an evolution from Adler and Thames Water now through to Petrofac, where the Court of Appeal is beginning to go in the right direction, basically saying if you're coming before the court with a cross-class cram-down plan, you need to set out very clearly, concisely, with good methodology, how the returns are being calculated on new money. How do you benchmark them to the market? And then, with respect to the residual value that's got to be distributed to the non-money contributors, and even those creditors who are contributing money, you've got to show what are their recoveries, and they've got to be pari passu. And if anyone's getting an enhanced recovery through a premium return on new money or through elevation or up-tiering, you better justify it. So I think everyone's got to go back to the grassroots and just run it through the waterfall, the pro forma waterfall, to show. And this is why I sort of despair that we've got into this mess, because we abandoned absolute priority. But that's what you would do in the United States. And everyone was saying in this country, oh, it's inflexible, you can't pay critical supplies. That's all taken care of under Chapter 11. So I think everyone's got to go back and start getting the pencil out and just being a little more precise about how you're splitting the pie.
Would anyone else like to take a stab? Well, that's fair. That's all the time we have for today, unfortunately. We're at 11:49 right now, so apologize for taking up a few more minutes than what we'd promised. But huge thank you to Dorian, Denitsa, and Luke for all your insights. And thank you to everyone for taking their time out of their busy schedules to join us today. We hope you found the webinar insightful and informative. Please stay tuned for a 9fin representative to reach out to you in the coming weeks about some of our product offerings if you'd be interested. And thanks again. Have a great week, everyone. We'll see you next time.